Welcome to Family Law Unfiltered with Emily.
Hi, and welcome back to Family Law Unfiltered with Emily Marx. I'm your host, Emily Marx, and today we will be talking about my bread and butter, defending against false domestic violence accusations. Unfortunately, false accusations of domestic violence are a reality in some family law disputes and prevalent in the court system. Reasons why people might do this. Domestic violence allegations can be weaponized to gain advantage in custody battles or out of spite or revenge, or to prove something to a new significant other or family members. And so successfully defending against a false domestic violence accusation is crucial to protect your reputation, parental rights, and your future. And I'm going to explain to you why. Unlike criminal cases, where the standard of evidence is beyond a reasonable doubt, meaning the state has to prove beyond a reasonable doubt that the alleged offense was committed, in civil domestic violence restraining order cases, a petitioner must prove his or her case by a preponderance of the evidence. This means credibility is key. What does preponderance of the evidence mean? It means that the evidence presented must show that it is more likely than not that domestic violence occurred. This is a significantly lower bar than in criminal court, making it easier for a petitioner to obtain an order and consequently more challenging for a respondent to defend against it. Meanwhile, it is important to note that being falsely accused, especially by a former partner, is devastating. The emotional toll, the anger, the frustration, the fear, the injustice, the delays, it causes an immense toll, takes an immense toll, and causes a lot of destabilization in the life of the person who's being falsely accused. However, it is absolutely critical to understand that while your emotions are valid, they cannot dictate your strategy or your demeanor in the courtroom. An emotional breakdown in court, an outburst, or even just appearing overly agitated can severely undermine your credibility in the eyes of the judge. Judges are looking for calm, rational, and factual truth tellers. Your lawyer, who is fighting for you, also bears the weight of this emotional toll. If a client is consumed by his or her emotions, it makes it incredibly difficult for their attorney to focus on the legal strategy, gather facts objectively, and present a compelling case. There's only so many hours in a day. Your lawyer needs you to be a partner in the defense and not a source of additional burden. My office has a no tolerance policy for this type of behavior. And so I advise my clients that if they are struggling, if they appear to be struggling with the emotional impact of false allegations, then to seek professional help, see a therapist, get validated that way while I work on your case. Let's talk about evidence. Because of the preponderance standard, even though the burden is on the petitioner, and we'll talk about that later, I approach all defense cases in the civil domestic violence arena as having to prove innocence. It's not written anywhere, it's not the law, but that's what I do. I believe that a robust defense requires meticulous evidence gathering and presentation and preparation. Let's talk about evidence that you should be gathering, not just if you're involved in domestic violence litigation, but if you're involved in any litigation or you anticipate any litigation, you should be doing these things. Let's talk about text messages and emails. Those are admissible. If the text messages and emails are from the other party, they are admissible. They are not hearsay. Look for communications that contradict the petitioner's claims. Look for communications that show a consensual or amicable relationship during the time of the alleged abuse. Also, look for text messages that may reveal the petitioner's true motives. in filing the domestic violence restraining order against you. Perhaps to get custody, and again, perhaps to get revenge, maybe to punish you. Call logs and voicemails. These can establish patterns of communication. These can prove who initiated contact, and they can also capture the tone of interactions, demonstrating a lack of fear, demonstrating manipulative intent. And before I go further, when I say gather these and maintain these records, maintain them in one file. Don't make it harder to get to gather the evidence if you need it later by having it, in 10 different places. Scan it, keep a hard copy file, whatever you have to do, but keep it together and keep it organized. In the meantime, however, be aware of laws regarding secret recordings. Generally, California is a two-party consent state pursuant to California Penal Code Section 632, meaning all parties must consent to a recording if there is an expectation of privacy. And this goes the same for photographs. There is an exception if you are recording or documenting abuse. So those types of exceptions would be relevant here. But if someone was not documenting abuse and attempts to introduce such evidence into the record, then you should and would, and your attorney will vehemently object. And this is actually happening to me in a case right now. I'm prosecuting the domestic violence, and I don't do many of those, but I do them when they are meritorious. And the other side has attempted to use character evidence, involving photographs and recordings that were taken without my client's knowledge. So those are not admissible. They will not be admissible. And really, that's the other party's entire case, just to demean her character. You can't do that. Another critical category of evidence are witness statements or witness testimony. Now, of course, you can't draft as a party a statement from a witness, but you can journal that a certain witness observed something, or a certain witness said something to you or expressed concern to you that is relevant to your defense or the prosecution. And such third-party witnesses and witness testimony is incredibly powerful. It's non-biased. It's objective. It could include neighbors, teachers, coworkers. It could include police officers. It can even include family members. I've had cases where the other parties or the accusing party's relative testified on my client's behalf. I don't know, what the motivation was there. I don't think it was vengeful. I think it was simply a situation where that witness was not comfortable with the false accusations being made against the other parent, my client in this case, because they had a decent relationship, and that relative witness was not comfortable. So we called that witness, even though that witness was a relative of the accusing party. So that does happen. But do keep the existence of witnesses, the statements of witnesses, do keep journals and records regarding that so that you can go back later and interview them should you need to. Police officers, if police officers come to your home, you want to get their name and badge number. The only other way to identify them formally is to issue a subpoena, and those take several days. And we'll talk about subpoenas, but try to get the badge number, try to get the officer's name, and then you can subpoena them to the hearing without going through the formality of the business record subpoena, which again takes time. Visual evidence like photographs and videos can be compelling. If the petitioner claims injuries in his or her moving papers, but photos from the alleged time that the incident occurred show no marks at all, or videos show the parties acting normally or even lovingly after an alleged incident, this can be highly persuasive. It's impeachment evidence. And that's really how you win domestic violence restraining orders where you were falsely accused, is impeaching the other party. Conversely, if they present photos of alleged injuries, You might have photos from the same time frame showing them without the injury or showing them engaged in activities inconsistent with their claims. These days, you can't tell when a photo was taken. You can manipulate photos and timestamps. So you may even file a motion or a request so that the court will order the other party to produce the phone so you can examine or have an expert examine the metadata. You don't want to rely on the court believing one party over the other in terms of when a photograph was taken. Really, sadly, these undated, untimed, or unmarked photos are often introduced into the record. They become evidence in the case, and they can be very misleading. So if that's going to happen, spend some money, hire an expert to review the metadata on the phone. And remember, for audio recordings, a transcription is required for a court submission. Now, if you have recordings that have audio, but the audio is not necessary, you just want the court to look at or watch the video portion and not listen to the audio, then no transcription is required. But if you want the court to hear the audio, a transcription is typically required for court submission. They do not need to be certified. But again, the importance and the benefit of having objective third-party witnesses cannot be overstated. And therefore, I usually hire an outside service to transcribe video recordings. You want to gather in your personal file police reports and medical records. Now, if you were the accused person pursuant to an incident where police were called out due to domestic disturbance at your home with the other parent, or wherever you were with the other parent or party, those police reports, if you were the alleged perpetrator, those will not be available to you. You will have to get a subpoena, but they are available to the person who initiated the report. Okay. So if the police appear at your home, hire an attorney, issue a subpoena, and get those records right away. Find out what the other person said that may and probably will contradict what was pled in their moving papers. I can't tell you how many times I have gathered police reports or subpoenaed police reports for my clients who've been falsely accused and found significant contradictions between what was stated in the police report to the officers and what was stated to the court. Significant contradictions. Sometimes the officers find the purported victim not credible. They might say that they're acting weird or, seem like they're on drugs or drunk. But of course, that's not in the moving papers or the request for the domestic violence restraining order. So subpoenaing that officer and having him testify as to what his report said about his impressions of the moving party would be incredibly helpful evidence. So you want to get your hands on those reports. Look at social media posts. We all overshare. Not we all, but a lot of people overshare. So look for posts that contradict claims of fear or abuse, show them enjoying themselves, show them being somewhere else on the date that they said they were being abused by you or the alleged perpetrator. Or posts that express love for the alleged abuser. Thank you so much. You're a great dad. Towards the alleged abuser, or show malicious intent, reasons why the party might be accusing you falsely. Motive is not evidence, but it's necessary to tell the story. The court's going to want to know, why is this person doing this to you? And so uncovering that and telling that story or weaving that story into the defense creates an aha moment for the court, and they appreciate the meritorious defense. Finally, your credible testimony, delivered calmly and factually, is essential. You're not going to want to plead the fifth. You're going to want to testify. You're going to want to prepare your testimony. In my cases, I prepare question and answer session scripts for my clients. I don't expect them to stick to the script at all. It's more for my benefit, so I know what the answer needs to be or what testimony I'm trying to elicit. But that's how you prepare. Prepare with your attorney. Stick to the facts. Avoid emotional outbursts. Your demeanor in court will significantly impact how the judge perceives your case in your defense and your credibility. So in terms of real-time record keeping, this is something you should be doing in any contested case: child custody, child support, spousal support, anything, any type of case. You should be keeping real-time records in journals. I know a lot of people don't like to journal. They can be bullet points, but trust me, you will forget some of the necessary important details, or maybe not so important details, after time. And you don't want to be impeached on something that you could have prevented, especially something you're telling the truth about. You want the court to believe you, so back it up with records. So start a detailed, objective journal immediately. It's not to vent emotionally, but factual entries only. Document dates and times, every interaction, phone call, text, email, or incident. Take screenshots of those, and with the emails, download them into files. Provide specific details: what was said, what happened, who was present. Note if videos, photos, or other documents or tangible evidence exists. Contact an attorney about sending out notices to preserve evidence if there is video evidence provided maybe by a public agency or a private business. You can send out letters to preserve that evidence in case you might be able, in case you have to use it later. That way, you will be able to use it later, even though it is not your personally recorded video. Document names, contact information of anybody who observed an event, possibly get a statement from them, even briefly. They don't have to write it, but what they saw, just to make sure that they would be a good witness for you. Keep it. And then when it comes to timeshare, and this is more about child support and custody, but child custody can be considered by a court sitting in domestic violence. So if a domestic violence restraining order is granted, or even if it's not granted, the court can still make child custody orders at that second hearing, the permanent domestic violence restraining order hearing. And so you want to document the timeshare, especially if you don't have court orders or you're not following court orders. That will be credible evidence about how much time each parent is spending with the children. I've used it. I've used it in child support court. The court found it credible. We just printed out Google calendars, blank ones, and we used one color for dad, one color for mom, listed the hours, and then I said in a previous episode, I believe, that there are 8,760 hours in a year. And so you can determine timeshare that way. Just lodge the non-custodial parent's time. Also lodge when they cancel or when they're late. Not so much for timeshare, purposes, maybe, but just to show that they're inconsistent. So if they're asking for more time, why is a judge going to give the other parent more time when the other parent's not exercising the time they already have? Also, these records, these journals, are an exception to hearsay rules prohibiting, out-of-court statements. Journals are evidence; they can be admitted, but they can also be referenced by a witness on the stand. If a witness cannot remember a certain detail, that witness can refresh his or her recollection by reviewing those detailed journal entries. And we can get the information into the record that way. Typically, clients want to save money. The best way to do that is to prepare and to know the testimony that has to be elicited. We don't want to introduce 30 pages of journals into the record. Judge is probably not going to read it anyway. We want to be able to testify as to the main points. So if a main point is forgotten, then the witness's magic words are, "I don't recall," to whatever question was asked. The witness says, "I don't recall," and the attorney asks if their recollection would be refreshed by reviewing a document. That witness says yes. The attorney hands the witness the document to review. The witness tells the attorney when she or he is finished reviewing. The attorney takes the document back and then asks the question again, affirming that the witness's recollection was indeed refreshed. So you don't have to have everything memorized to get up on the stand. You can prepare notes for yourself and you can refresh your recollection with those. Those don't have to come into evidence. We don't even have to ask to introduce them. We just can articulate to the court that we have a document that will refresh that witness's recollection, and typically the court will allow the witness to review it. Now, presenting the evidence that we've talked about is not always straightforward. Especially if the other party is represented, you will likely encounter objections, particularly hearsay, relevance, and foundational objections. This is the best reason to get an attorney. Attorneys are familiar, or should be, with the California Evidence Code and can work around some of the black letter law that may be misinterpreted, although is relevant. And therefore objections may be initially sustained. You can overcome those objections and get your evidence in by knowing the exceptions to the hearsay rules and other applications of the statutes regarding evidence. Some hearsay exceptions that often apply in domestic violence cases include state of mind. So if a document reveals a party's state of mind, and it doesn't even have to be the other party. If it's the petitioner's state of mind, it's not hearsay. The other side's statements are not hearsay. Out of court statements or documents, those are not hearsay. Statements made in documents. Third party statements made out of court are hearsay. So if a text message reveals a witness's state of mind, or even a non-witness, a person's state of mind, rather than proving the truth of what they said, it might be admissible. Another hearsay exception commonly used is a party admission. And that, I've mentioned this a few times, a statement made by the opposing party, in the case of a DV defense, would be the petitioner. Those are admissible as party admissions. They're texts, emails, prior statements to others, anything that contradicts their current claims are allowed. That's not hearsay. Now, your prior statements are hearsay, but the other party's prior statements are not hearsay. Conversely, your statements, out-of-court statements, are not hearsay if used by the other party, but you can't use them. You can't use them to corroborate your own testimony. Prior statements made by the other party, which contradict their current testimony or statements that they included in their requests for domestic violence restraining orders, are admissible. And those are used for impeachment all the time. That's why you want to read with, go through it with a fine-tooth comb, the allegations that are pled in the petition, in the moving papers, the request for domestic violence restraining orders. Read that. Know what they testified to. Know what they said in those papers. And then listen to what they testified to at the hearing. And if they are different, you can use that prior statement to impeach the party who is making the inconsistent statement. The only caveat is that you have to get that that request for domestic violence restraining orders that was filed into evidence. For that, the petitioner has to acknowledge that they reviewed and signed the request for domestic violence restraining order that was filed, that resulted in the hearing, and that is their signature on the document. I had a case once where the petitioner who I was cross-examining could not recall if she signed the document and could not recall having read it. So I could not get that document into evidence. Of course, it went to her credibility, and she ended up no-showing on day 2 of cross-examination. So the matter was dismissed regardless. But that does happen. So, in order, you have to have some level of cooperation from the petitioner in order for certain impeachment evidence to come in based on prior statements. But if the judge sees the witness acting hostile, they note that, they see that. And judges are allowed to consider demeanor, and they do. We talked a little bit about police reports. Those fall under hearsay exceptions. If they are produced pursuant to a subpoena. And same with medical records, but those are protected by HIPAA, and usually the other party or the accused party has to bring, well, not even the accused party, either party has to bring up the issue, has to tender the issue of their health or the other party's health in order for medical records to be available pursuant to a subpoena. It's quite difficult to get medical records, even psychotherapy records, even for children. Something that I don't often do. I don't even know that I've ever done it. I usually just weave it into motive if there is one. However, if the other party produces medical records, I'll certainly use them. Finally, the hearsay exception that I use often when children are involved falls under spontaneous utterance. A spontaneous utterance is a statement relating to a startling event or condition made while the declarant was under the stress or excitement caused by the event or condition. What's key and what's so helpful is that the statement does not have to be made at the moment of the incident. The key is that the declarant is still under the stress of the excitement. A real world example case that I have handled involved a 13-year-old boy who wrote a letter, I think 48 to 72 hours after the incident involving alleged abuse. And we are moving to have that entered into evidence as a spontaneous utterance, even though it occurred 3 days later. Why? Because he was still under the stress of the excitement. How do I know that? Because his mother is going to testify that he was still that he was crying and upset, and wasn't going to school, couldn't even go to school, didn't want to go to school for those 3 days. So that is a powerful exception and can be used for children so long as the child is of an age to where the court can determine that he's capable of reasoning and telling the truth. Evidence is relevant, and you'll hear relevance objections. Sometimes the court will even make a relevance objection sua sponte if they don't know where you're going with it. I've had that objection made to me, and I asked the court, please just give me a couple more minutes. I'll tie it all together. And judges usually will give you that time. Evidence is relevant if it has any tendency to make a fact at issue more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. To overcome a relevance objection, be prepared to articulate why your evidence is pertinent to the claims of domestic violence or to the petitioner's credibility or motive. For instance, if a petitioner claims fear, but you have photos of them willingly attending a family event with you after the alleged incident, or a text message telling you what a great dad you are, what a great mom you are, that evidence is highly relevant to contradict their claim of fear. If they claim financial abuse, but you have bank statements or credit card statements showing that they had full access to and spent funds, that's relevant. But most notably, like everything else in law, the key to overcoming objections is preparation. Understand the rules of evidence, anticipate potential objections, and be ready to articulate the legal basis for admitting your evidence. Otherwise, the objection will be sustained. The court will not articulate or argue an exception or reasoning for why your evidence is admissible for you. You have to be prepared to do that. And that is one of the best reasons to hire an attorney, because Evidence is a semester in law school. You can't learn it in 2 weeks. So while legal counsel is invaluable in this area in determining what evidence is admissible and preparing your evidence for admission, they also can craft compelling arguments based on that evidence and navigate the procedural pitfalls of court. I have had clients who hired me only to prepare documents or counsel them up to a hearing, and then they were going to self-represent. I tell them everything to do and everything to accept, and I draft pages and pages of preparation, and then I call them after the hearing and I say, how did it go? And they said, terrible. They're crying. And it wasn't because of anything I didn't or did include. It was because something that the judge said that they weren't prepared for threw them off their course. They weren't able to get the statements that they wanted to get into evidence. It all just went to pot. And so no matter how prepared you feel, if you can afford it, you want to hire an attorney, because it never goes as planned, no matter how prepared you are, unless you're an attorney. As an attorney, I can predict 75% of what will happen during my hearing. And that makes me comfortable and should make my clients comfortable too. Beware of something called impeachment on collateral issues. A common tactic in cross-examination is to try to impeach a witness on a minor, irrelevant detail. This is called impeachment on collateral issues. While it might seem harmless, it can undermine the party's overall credibility, and it really annoys the court. The court doesn't want to know about a lie a witness told that's completely unrelated to the litigation 10 years ago. Okay, they just don't. We want to focus on impeachment on material issues. Okay. Now I want to talk about something. This is one of my favorite tactics, and it's moving for a directed verdict in a domestic violence case where I represent the falsely accused party, and it is allowable pursuant to California Code of Civil Procedure 631.8. In California, after the petitioner has presented all of their evidence and been cross-examined, the respondent can move for a directed verdict under Section 631.8 of the Code of Civil Procedure. When to use it? If the petitioner's case is weak, inconsistent, or if their testimony has been sufficiently impeached to the point where no reasonable judge could find by a preponderance of the evidence that the domestic violence occurred, you can make this motion. You argued to the judge that even after accepting all of the petitioner's evidence as true, they have failed to meet their burden of proof. You highlight inconsistencies, lack of corroborating evidence, and successful impeachment of their testimony. If the judge grants the motion, the case is dismissed without the accused even testifying. You don't even need to present a defense. It is a powerful tool to end a meritless case early. However, it requires a very strong showing that the petitioner's case is fundamentally flawed. I've had judges grant this motion. It's beautiful. It really feels good because the court typically makes findings after granting the motion on the petitioner's credibility. One judge noted that the petitioner was appearing to fabricate, and that was a case I had last year. We've been using that quote. We got the transcript, and we've been using that quote in every motion or response or court appearance on that case ever since. She can't get away from it. And so that is a tool that not only saves you, not only reaches a just verdict, but saves you so much time. Because even though you have to pay your attorney to prepare your direct examination, you don't have to prepare for the hours and hours and hours it's going to take to testify and to articulate a closing argument and to go through cross-examination and call all your witnesses. All that evidence that we gathered, we never use it, and that's okay because introducing evidence takes time. And time is money. So you save quite a bit of money if you get your 631.8 motion granted. I think we'll talk about subpoenas in another episode, but subpoenas should be utilized in any domestic violence case, or really any case at all. There is so much at stake, and I'll go into this in just one moment. There's so much at stake if you're found liable, or one who has committed domestic violence within the previous 5 years. So much impact on custody. It can impact. Can't really impact property division, but it can impact attorney fees, your standing in the community, your freedom. There is so much at stake. These hearings are set on an expedited calendar. So a lot of times people just want to get it over with. No, that's not what you want to do. You want to prepare your case thoroughly. You keep continuing, you keep requesting continuances, not because you're not diligent, but because it takes time to get documents back when you issue subpoenas. You continue your case until you have all of your evidence to proceed. Because even though it's just a civil DV, it can have far-reaching implications. So we'll talk about subpoenas, issuing subpoenas, utilizing subpoenas in a future episode. There are different types of subpoenas. We'll talk about when to use which, and how they differ. Defending a domestic violence restraining order is not inexpensive. As I discussed, it's an expedited process. It's comparable to litigation in any division of the court. It involves significant legal work, but it's done in a shortened manner to preserve a party's constitutional rights, because certain rights are taken away, including the right to own firearms, by virtue of being held liable or found to have committed domestic violence. So you have to keep going back to court and, renewing your request for continuance because you don't have all your evidence. But once you have all your evidence, you go. So you should expect legal fees and costs to run upwards of $15,000, and potentially higher, $20,000, $25,000, depending on the complexity, the number of witnesses, and the duration of the hearing. This is comparable to other family law contested matters, but the compressed timeline for domestic violence restraining orders means that the costs can accumulate quickly and put financial pressure on the person who's being accused. I often tell my clients that if the allegations contained in the request for domestic violence are true, and of course, if they do rise to the level of domestic violence as articulated by the Family Code, there are 2 code sections that apply, then it might be more advantageous for them simply to agree to the restraining order, again, if it's indefensible, and focus efforts on trying to overcome the presumption against custody by complying with the terms outlined in Cal Family Code 3044 and otherwise. That would be a better expenditure of $20,000, $25,000 than defending against a domestic violence restraining order that is more likely than not to be granted. That's the sad reality. If the allegations are true, consult with an attorney about, the other party's ability to prove them, the type of evidence they would need, and determine whether or not it's better to oppose that request or take affirmative action towards overcoming the presumption against custody in the future. Now, on the other hand, if you are being falsely accused, and this is where, I said this is my bread and butter, this is what I love to do. If you are being falsely accused, you want to pursue it. You want to find an attorney like me who believes in your case and who's willing to work on it and who takes great delight in impeaching liars. And you want to be aware that prevailing party attorney fees are available to litigants in California in domestic violence restraining order matters. So if you are falsely accused and you prevail, and the restraining order is not granted or is denied and dismissed, however you want to say it, you can seek attorney fees for having to defend against that meritless claim. A lot of my clients don't pursue that relief, even though he or she prevailed and the domestic violence restraining order was not granted. The allegations were not proven. A lot of my clients declined to go after the $25,000 they spent in defending against those meritless claims. This is for two reasons. One, it's expensive. It's expensive to file an attorney fee claim. So it's more money out of pocket. They've already spent $20,000. They don't want to spend more. So that's one, practical reason. The other reasons seems to be an emotional one. A lot of my clients who have been accused and proven that they were falsely accused of domestic violence, for some reason, feel some sort of sympathy towards their accuser. I don't know if it's Stockholm syndrome. I don't have a degree in that, but it happens more than I'd like it to, because what ends up happening if you don't do that, if you don't punish the party who lied to the court and tried to ruin your life, if you don't punish them financially or otherwise, and there is no otherwise, by the way, you don't go and beat them up. So if you don't punish them financially, they're going to do it again. The cases where my clients do not bring attorney fee requests based on the prevailing party statute, they get hit with requests for order to modify custody. They get hit with, requests for order to put child in certain school. They get hit with small claims suits for property, if the parties weren't married. They don't stop because I think it's because the people who tend to make false allegations are obsessed with winning. And so if they keep losing, they lose the domestic violence, they lose the follow-up custody motion, they lose the small claims. They just, they're just trying to get a win. And in my experience, that's what it's about for them, is just being right, being proven right, explaining or justifying to their family and friends, oh, that judge got it wrong. That judge is stupid. That judge got it wrong, until they can finally get a win. And so you can stop that conduct in its tracks by just filing that attorney fee request, asking for $25,000. Chances are they won't file again, at least not frivolously. Before we wrap up this episode, I want to make sure that you listeners understand the difference between the temporary and permanent domestic violence restraining orders. When a request for domestic violence restraining order is filed here in Orange County, California, the court will issue a temporary restraining order if the allegations as pled meet the definition of abuse under the Family Code. And those will expire, those temporary restraining orders will expire at the hearing 21 to 25 days later, or whenever, if that gets continued out, they expire, at the future hearings. They continue to expire. There is no finding of guilt or innocence. You should take no offense to it. It is common. I would say like 80 to 90% of requests for restraining orders are granted, because if the petitioner lies and those lies amount to abuse, the temporary restraining order will be granted. Later on, when they have to prove it up and they can't, it will be dismissed. Okay, so that's the difference between the temporary and the permanent. Don't take the temporary restraining order includes no findings. Okay, it's just, did the allegations as pled amount to abuse or under the Family Code? If yes, it gets granted. Okay, next. Very briefly, I just want to reiterate that the Family Code 3044 presumption is the reason why people often fight against false allegations so hard. And that is because of that 5-year presumption against awarding a parent who has been found to have committed domestic violence, not even in this case, but even against other children, other parents. It doesn't even have to be in a case, against having even joint legal or physical custody. So you absolutely do not want your children in the custody of a parent who is willing to make false allegations against you under penalty of perjury. That's probably not a good parent, probably not a healthy place for your children. So that is the primary motivation for a lot of people who are defending against false accusations, in addition to, impacts on their job, if they have to carry a firearm, public records, and things like that. But the 3044 presumption is powerful. It does not afford the judge much discretion at all. And it is a motivating factor for many of my clients anyway, in defending against false accusations of domestic violence. And that's about it for now. That's all that I have time for. If you have questions, please post them in the comments and I will answer them. And then going forward, next year in 2026, or maybe it'll be 2026 by the time this publishes, I will be publishing additional podcasts on questions or common questions that Orange County litigants have. I'll continue to research that and answer any questions you have in future podcasts where we can talk about support, we can talk about property division, or anything else that comes up in the comments. Thank you for watching. I appreciate you taking the time, and we'll see you in the next one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.